Charlie. Next time. US. The privilege once again.
So that I do not forget this. Do you like football?
Pardon me.
Do you watch football? Are you interested in the Black Stars at all?
Since 1994, I started watching football with my head rather than my heart. That was when we were playing a World Cup qualifier, and I think was it Algeria or Tunisia, and we were taken to some desert and wet playing turf where the ball would not even bounce. Those were the days of Ameteefe. They succeeded in breaking our hearts and eliminating us from the qualifier. Since then, I do watch, but I just watch with my head, not so much with my heart.
Oh, okay. I've been told that is Algeria. It was Algeria that we faced.
Fantastic. Was it 1994 or 95?
Yes. Okay, I'm not so sure.
I had a heartbreak. My heart was broken. I couldn't eat dinner.
Okay. So since then, you've been following with your head.
Exactly.
So no matter what happened, you can even still be eating whilst the game is ongoing, whilst the team is losing.
That has been the case.
Oh, fantastic. So what is your head telling you about today's match?
Oh, we're going to have a very good match. Let's tell you, I don't know our boys too well.
Okay.
By their names. But England is one country that when we are facing them, I don't care.
Okay.
They have the flair. I've watched one of their matches. They love to pick the ball. But Ghana won't allow them to do that.
Okay.
That I can be sure. My only advice to our boys is to avoid being sluggish when it comes to taking of the 50-50 balls.
Okay.
Because the moment they delay, they are compelled to go and have a hard tackle, and the task will be flowing. That they must avoid if we do this right. I'm telling you that England will have a hell of a time with us.
I see. Okay. Is it a win or a draw?
We can win this game.
We can win it.
Yes. England is beatable.
England is beatable.
They are beatable.
I see. Well, now let's turn to the trial in absentia. What does that mean? And under what circumstances does that even arise?
Well, I was listening to one of your guests, or I don't know whether it's
yes, my colleague Lavon. Yeah.
Okay, and he was making the point clear. I thought that you have allowed him to conclude, and I will only say I have nothing useful to add. Okay. He referred to Article 19.3. To be honest, there is no express provision in our statutes or procedural rules or the Constitution, for that matter, spelling out very expressly and in clear terms how trials in absentia should be conducted. And so we should examine that on case-by-case basis. In the Sedina case, I think, if I recall, she was within the jurisdiction when the trial commenced, and I believe appeared in court at the preliminary stages and was even on bail before she traveled health ground, and since then never returned. So the trial continued. In this particular instance, I don't know whether at the time Ofori-Atta and probably some of his other accomplices left the jurisdiction, they had actually been charged and did appear before any court, whereby his plea or their plea had been taken.
No.
I don't know.
No. Factually, nothing of such happened.
Okay. Yeah. So, in this case, the article that your colleague referred to will serve as the basis for any discussion. Whereas the entire Article 19, which comes under Chapter 5 of the Constitution, where we have all our fundamental human rights and freedom guaranteed. Fair trial rules have been very clearly spelled out under Article 19, and one of which is the requirement that a person charged or accused of any criminal act should be tried in the presence of the person. But then there is that proviso that unless the person decides otherwise, having been notified. Okay. In this case, yes, trial in absentia is recognized if the accused person decides to waive that right to be present after he or she has been notified or had notice of the indictment. In this case, we then have to look at the methods by which the notice of the commencement of any criminal proceedings could be brought to this accused person or the suspect for that matter. Now, ordinarily, he would have been invited by the law enforcement, police, CID, the EOCO, OSD, and so on and so forth. He would have been invited upon a complaint of some wrongdoing by a complainant. In this case, the victim is the Republic, all of us. And the complaint then trigger investigation or an inquiry to the said complaint, where evidence is gathered, a document is opened, and possible charges referred, and then he would have been notified of a court date simply by just being informed that you are to appear in court today or at this time, and so on and so forth on these charges. I don't think that has been done or could be done at the sequence. He is not within the jurisdiction. So when this is not possible, what's next? Criminal summons can be issued. And if you look at the procedures provided under our criminal procedure code, that's the Ameteefe, it's set out in clear terms how proceedings in criminal actions have to be brought to the notice of the person accused. Personal service is required first. That is the norm. That the person must be served personally by delivering a copy to him or her. When personal service is impossible, then you go to the next question. The law requires that a copy of the summons is delivered at the person's last known place of abode or workplace. And this to be given to any adult person 18 years and above, to be given to the person under investigation or the accused person. When that also is not possible, there are other means whereby the summons could be posted or affixed to any conspicuous place of the last known place of abode or the workplace for the attention of the person. And these are some of the things. So, Ofori-Atta is a well-known figure. At least his last known place of abode is there. His workplaces, his companies, and others are there. But the state is aware that he is not within the jurisdiction. But I don't see any exception in terms of criminal procedure that prevents the state from having this most of service utilized in the circumstances. Unlike civil cases where once the plaintiff knows that the defendant is not within the jurisdiction, such most of service, including substituted service, is not allowed. But that there must be a specific order or leave to serve out of the jurisdiction. We don't have any such equivalent provision in the criminal procedure rules, whereby leave has to be sought from a court to serve criminal summons outside the jurisdiction. Remember that no country has extraterritorial jurisdiction over fugitives that are hiding in other jurisdictions. Therefore, the suggestion is that once the charges have been properly laid and filed before a court of competent jurisdiction, these charges must be brought to the notice of Ofori-Atta by all the means available. And by issuing criminal summons duly set on him at his various places of work or home, he will be deemed to have been properly sent or notified. And the choice will be for him to take advantage of the fair trial, to be present and be informed of all his rights guaranteed by constitution and law, to face his accusers and to defend himself. If he chooses to waive these rights, I believe that once the notice requirement has been satisfied, the state or the prosecution can proceed.
I see. Okay, because I was coming to ask you about whether it is possible that they can work with U.S. authorities to serve him at his residence in the U.S. But you're saying no such powers exist?
No, I haven't seen any procedure by which summon or criminal summons be served through the foreign authorities, unlike in civil cases. However, there are other provisions under the EOCO Act and the OSC Act. They call it mutual stance. I don't know whether it can avail them any such help to explore this mutual assistance to set a criminal summons out of the jurisdiction. Otherwise, summons are not the only means by which a person accused of a criminal act is notified or brought before court to seek justice. Warrants are also a different level. When summons, for instance, fail, warrants are issued commonly. So, a warrant may be may be issued, at the request of the prosecution by the court. Once a warrant is issued, an arrest warrant, there are international arrest warrants.
Mm-hmm.
So when international arrest warrant is issued, then the government of Ghana, through the Attorney General, will be making a request from the jurisdiction where Mr. Ofori-Atta suspected or known to have been hiding, for his arrest and possible return to Ghana. Then we come back again to the issue of what we call extradition.
So the number one hurdle that you face when you're dealing with trial in absentia, because listening to you, is service on the person, making sure that the person is notified of
the initial charges. He must know, and how to bring this to his attention is the hurdle to be crossed. It isn't so much about the procedure, the trial process itself. Okay,
Mhm.
it has more to do with bringing to this notice the party late.
Mm. I see. So in this case, is it for you to because all these processes go through the courts? At
Yes,
what point in time would perhaps the court be convinced that you've made adequate attempts, or the court would have come to the conclusion that either you have attempted to or you have done everything you can to serve him?
it is so obvious that personal service is not possible. But the other means are there. Without exception, when a copy of any summons are delivered to any adult, inmate, or occupier of the premises that the Ofori-Atta and others are deemed to reside or at their workplaces that are indisputably theirs, of course, that will be deemed to be sufficient notice. Okay? If
Okay.
after all this notice or notices, he still fails to avail himself, and the state feels so strongly that there will be the need to bring him personally to court, then the warrant may be considered. But that itself will have to face the challenge of having to go through the U.S. authorities and then coming back to the same point of
Extradition.
extradition and all that. But at least at that stage, there's evidence before the U.S. authorities that he is facing some well-laid and clearly stated criminal charges,
Mm.
and that attempts were made to reach him and to bring this to his notice to be present, and that he will simply not take advantage of that. Then the compelling powers of the state or the coercive powers are triggered through the issuance of the warrant of arrest.
Okay. So if they get to the stage of this where they think that we need a warrant to be issued, can the case continue whilst that warrant is operational?
Well, of course, he has waived his right, but the only challenge I face, I stand to be corrected, is will he be deemed to have pleaded not guilty? In the case of Ferdinand, at least he was in court
Yes.
when his her plea
Was taken.
was taken. Okay, she did not plead guilty. That was why there was a hearing or a trial. So how is the state going to take the absence of Mr. Ofori-Atta to mean that he is deemed to have pleaded not guilty and therefore there should be a full trial, or he will be deemed to have pleaded guilty and therefore he must be convicted on his plea and sentence as such in absentia. These are also very technical procedural issues for the prosecution, the Attorney General's Department
Mm.
on that open.
So from service, you have the issue of a plea.
Yes.
So all that will be argued before the court. The court has to be satisfied before the case can proceed. Once the court is not satisfied, it means that it must wait until the man appears to plea.
Yes, because in ordinary criminal cases that some of us have defended, after all the pre-trial procedures, out of court procedures, normally at the police station, you go and so on and so forth. When a lawyer is involved and the prosecutors are charitable or the investigators, they call and inform you that the matter is coming up for uh, hearing today in this court and at this time. Very informal. Or the accused person is informed that we are in court tomorrow at this time, in this court. And then by that time, the person may have been on some problem while doing it. And therefore, you come voluntarily to court, whereby once a charge sheet has been duly laid and filed, the first thing to do is, unless the prosecution is not ready to start, the plea is taken. And then probably a repeat bail application is made, and the person is admitted to bail or is remanded to reappear, or is remanded while the plea is deferred. It is when the person fails to voluntarily show up that the next stage is triggered. That is to say, a warrant, a summons, formal criminal summons are issued, or a warrant of arrest at the highest level. In this particular case, much of these that I've talked about are simply not available. The options are not available.
I see. So very interesting waters that we are swimming in. But in this case too, I realize that the Office of Special Prosecutor has been communicating with a law firm that claims to be representing Mr. Ken Ofori-Atta. Does that make anything easier?
Yes. In criminal procedure, the rules are not as strict and technical compared to the civil cases. Okay. Remember that there were earlier invitations. OFC, they have been in touch with these lawyers because on previous occasions, these lawyers appeared as his lawyers to represent him in some pre-trial and pre-trial out of court proceedings having to do with the matters that are leading up to the charges being preferred. So these lawyers have established a relationship with the OFC. They have held themselves out as having Mr. Ofori-Atta full authority so to represent. So they have been communicating to them. Copies of the charge sheet and whatever have been shared with them for the attention of their client. So it will be in their own place and the client is there to adhere to this belief for his plea to be taken, and thereafter he chooses to go up. He will be essential. And even if he still doesn't need to volunteer upon all the no request or brought to his attention, of course, it may become necessary to issue that warrant of arrest, and Ghana may have to depend on the processes allowed by the U.S. authorities to have him arrested and extradited to Ghana. If that also doesn't work, what next? Will he be deemed to have waived his right to have his plea taken? And if so, what plea will be entered for him? Will it be one of outright admission of guilt, for which there will be no need to take any evidence by his convicted and sentenced on his own plea in absentia? Or he will be deemed to have pleaded not guilty, for which reason full-blown trial is commenced. These are some of the issues that may be of concern to the Republic and the Attorney General.
I guess you will also be watching this closely to learn how this proceeds. But in all your readings, I know you do the Ghana Law Report, where they deal with precedents from as far back as the 80s. So you also read from across the world, among others. Have you come across anything of such, especially within our jurisdiction? Is there precedents that can be followed?
Not at all. I haven't. I'm yet to.
None?
By all means, there could be something. I have not conducted any research on it. In fact, within our law, especially this same Article 19 and then the provisions of the Criminal Procedure Act 30, the only time that a plea is presumed to be one and nothing else is those capital offenses that carry the death sentence. I'm told even death sentence provisions are in those cases where if a person pleads expressly pleads guilty, a non-guilty plea is entered because by all means the state is required to give some evidence. Okay. But I haven't come across a situation where a plea, a failure to take an accused person's plea because he or she will not avail himself that purpose. That absence is deemed to be an automatic plea of guilt or a no guilty plea. We can still find out something on this, and I think there are more knowledgeable people when it comes to criminal prosecution and defense. We can still find out. I must be honest, I'm yet to do any serious research on it.
Okay. Now, let me conclude by asking you a question, because all this started with the special prosecutor saying we need him to answer some questions. I know you perhaps you have represented clients who perhaps initially the authorities thought were guilty of something, but after appearing before those authorities during the investigative process to answer some questions, they were convinced that the guy had no question to answer. In this case, is the hand of the Office of Special Prosecutor being forced? Because perhaps if Mr. Ofori-Atta has appeared to answer those questions, he may not have even been on the charge sheet at all. Is his hands being forced?
Somehow, yes. You are right. The procedures adopted by the law enforcement, the investigative body, are not devoid of the usual due process requirements of a fair trial. We're talking about fair trial when the matter is in court, but before the matter goes to court, there is also due process. And so due process doesn't only occur when trial begins. And therefore, it is fair for the law enforcement to whom a complaint has been made, although it's a state agency, and the complainant being the state or the republic, the law enforcement, the investigative body, still deems it necessary to hear the suspect. At that stage, the person is only a suspect. To clarify matters. But remember, no suspect is under any obligation to afford the investigative body the opportunity to build a case or to arm the investigative body with information or evidence to prosecute it. Because remember, there is also the right to remain silent. So even if Mr. Ofori-Atta had appeared before them, he will be reminded of his rights, all the several constitutional rights, including the right to remain silent. He could choose not to talk and say, look, my silence is my response, and I stand by it. I reserve my comments or my statement for court. I don't intend to talk to you. That will be it. But then, his silence may not help in certain circumstances because, after all, some of the matters could have been clarified and the state would be so satisfied that this is not what we thought and will not even warrant a further step. It ends there. Rather than keeping mute only to be charged with, let's say, frivolous offenses, but you are taken through the trial process for years. Your liberties are curtailed because each time the case is called, you must be there. So it doesn't help someone who has a genuine and solid defense or explanation to fail not to speak on all occasions. It is only when the state is trying to engage in an act of inquisition, trying to extract evidence from a suspect by unfair means in order to build their case, that a suspect will exercise that right to remain silent.
I see. There's a lot to look forward to. Thank you very much for speaking to us.
I'm very grateful, Bernard.
That's Lawyer David Ameteefe. Join us on the line. But let me remind you that if you're looking for a place to buy electronic appliances, Hisense is the best place to go. Everything you need all under one roof is one of the top electronic companies in Ghana. Because they are committed to the quality of their products, they will offer you up to a 5-year manufacturer defect warranty on their items. Hisense showrooms conveniently located across Ghana.